Joining us now is James Burnham, partner at international law firm Jones Day. Hello there, James. So DC is trying to figure out what to do with crypto, and maybe you can outline some of the problems in regulatory clarity that is befalling the industry right now with all these regulators trying to claim a piece of authority.
Yeah, thanks, Christine. I appreciate y'all having me on. It's great to be here. So I think maybe I just want to set the stage because a lot of the discussion about crypto regulation sort of feels like it happens in a vacuum. And people are just looking at whether this or that agency, what are they going to do? What's going on? What's the narrow thing? But the Supreme Court has changed the law governing federal regulators in dramatic ways in recent years that is really bad for regulators and really good for people who think there shouldn't be more regulation. And so what I mean by that is they've announced a rule basically that says major questions of legal policy and economic policy and social policy have to be decided by Congress first. And so before a regulator can do something, Congress has to clearly give it the authority to do that. And the best decision you can read on this came out over the summer. As you may recall, there was a moratorium that the CDC placed on evictions in relation to COVID-19. And the Supreme Court said the CDC did not have the power to do it because the statute they were invoking was very old and did not clearly give them power to regulate the housing market. So when it comes to the DC dogpile today, I think what people don't need to keep in mind is that just because the regulator says they can do it, or just because the regulator claims to have some sort of legal argument that gives them the power, that's not the whole story. And really Congress, what the Supreme Court has told us is Congress has to take the lead here. Regulators can't just do whatever they want using statutes from the Great Depression that include vague language that might arguably be applied to digital assets.
Well, it's interesting in the context, in September, the SEC threatened to sue Coinbase, and CEO Brian Armstrong slammed them for taking a regulation by litigation approach. But you believe crypto firms should actually potentially use affirmative litigation to push back on regulatory overreach and obtain a clear regulatory landscape that way. Can you explain, is this happening?
Yeah, no, absolutely. So it's never happened with the SEC. I mean, basically, there's two pieces to this. So if a battle is coming, you want to be the person who chooses the battlefield, right? You want to be on top of the hill, not at the bottom of the hill. One of the reasons the SEC has been so effective over the years is because they generally are the hunter, not the hunted. They are the ones who decide who to sue, where to sue, when to enforce, and how to do it. There are other contexts in which people have challenged laws and regulations before they are applied to them. And the basic theory of this is you shouldn't have to commit a crime before you find out whether what you did was actually a crime, right? So if you say, let's say you want to launch a token and you're concerned that the SEC is going to say that that's a securities offering. So if you launch the token, you've already committed the violation of the securities laws if they decide that it was a security and the courts agree. But there are ways you can sue the SEC beforehand. It's called a pre-enforcement challenge, where you can ask a court to declare that that it's not a security, that under the securities laws from the 1930s, the token offering that you want to launch would not violate them, would not fall within those laws, and therefore the SEC can't come after you. That is something that you could then bolster with the point I made earlier about the Supreme Court saying agencies have to have very clear statutory authority from Congress. The Securities Act is literally from the 1930s. And so the notion that Congress in the 1930s was saying anything about the blockchain or digital assets or even the internet is obviously just ridiculous. And so I think you would have pretty good sort of broad arguments that the narrow terms of that bill don't cover things that are happening, of that legislation don't cover things that are happening today in the digital asset space. And so the point, though, I think, is just that you shouldn't have to wait until they come for you. If you want, you can try to be more affirmative and go after them. Now, the details matter. It would be, it's very complicated to put these kinds of cases together, but it's something people need to think about because there's no reason why we have to wait for them to come steal our lunch money. We should think about going and roughing them up first.
So, James, I don't know if you got a chance to hear Wade Perry's discussion with us from First Bank regarding the launch of their stablecoin. He said that he was engaged with the regulators there, the FDIC, OCC, et cetera. So it sounds as if that at least there's some proactive involvement by regulators, obviously, in some amount of cryptocurrency creations. And my bigger question with that is, are we seeing now these regulators all jockeying for position, if you will, just trying to get as much territory as possible now before such legislation is written, so that when it comes time to go in front of Congress, they say, well, we already do that. Why don't you just solidify this in a law?
So Lawrence, that's a great point. I think that is absolutely right. So I guess I have two thoughts on that. First, you have to think about incentives, right? So a regulator, an enforcement entity, especially an enforcement entity. I mean, the Fed is not. It's not designed to be an enforcement entity, right? The Fed is the central bank. They run the monetary policy for the country. But the organizations that exist solely to go after people, to enforce the law, the SEC, the CFTC, the Justice Department, those are sort of the hammers of the federal government. And as you know, the old saying is totally right, which is that when you're a hammer, everything looks like a nail, right? And so when you're the chairman of the SEC, if you're Gary Gensler or whoever, you know, you have a strong incentive to do as much as you can during your time at the head of an agency. And that, to go to your point, means you have a strong incentive to try to be as aggressive as possible in pushing the boundaries of the law to bring new things into your regulatory domain. In my opinion, that is the absolute opposite of how regulation should go. Regulation by enforcement, regulation by people who have every incentive to push the limit as much as they can is the absolute wrong way to make policy. And that, I think, is what the Supreme Court has been saying in these cases, is that regulators don't just get to go do things. Congress has to give them authority in advance. And so, and I think when you do that, humility and caution and trying not to cause more trouble than you've avoided are sort of the watchwords of the day. I mean, Congress has to operate by consensus. It's often in gridlock. That, I think, is more of a feature than a bug, because that means when things come out of Congress, generally, they tend to be more thought out than things that regulators just wake up one morning and decide to do. And so the key, I think, is just to make sure that you don't destroy products in the name of protecting their consumers. You know, we all think consumers should be protected. Obviously, that's a good thing. But I don't think the best way to protect consumers is just to destroy the product that they want to buy.